wind is the price of competitive sources of energy. And so public choice theorists say, well, this is really how government regulation works in a lot of realms. It's just a club that businesses use to beat up on each other. But with this industry, regulation is the business. The entire business model is premised on government creating regulatory constraints that are challenging enough for clients to navigate that they have to hire out compliance. And at the same time, if the public sector and if the private sector aren't doing well enough to hire consultants, in other words, if they're getting strangled by regulation, then the industry falls apart. So it needs just the right amount of regulation and just the right complexity in order to thrive. So that's, I think, interesting and distinctive. And there are also two areas of academic inquiry that this industry, I think, is particularly relevant to. So one is the privatization of government services. This is a trend that academics talk about a lot, policymakers as well. The basic story is that an increasing amount of the work that once was done by governments is now handled by private contractors. And it includes not just ministerial tasks, but sometimes work that we think of as classically governmental, things like handling national defense or running prisons. And there's been a lot of debate in academic circles about whether this is good or bad. Some of the proponents say, look, you get a lot of efficiency, you get more talent, you get more nimbleness, you get economies of scale and better specialization from the private sector, and therefore privatization is great. And then at the other end of the spectrum, you have academics who say, well, when we privatize, that means making end runs around the constitutional and statutory constraints associated with public law. It also means giving work that was once classically governmental to people who are just going to commodify compliance. They're just going to turn it into something that can be bought and sold without any real attention to the values underlying public law. So this has been a debate in a lot of different areas of governance. It has never really, environmental consultants, we will hardly ever see come up in these debates, but I think they're directly relevant to it because a lot of the work they do involves policy-oriented decision-making involving a fair amount of discretion under public laws, but being done by private entities. And I'll talk a little bit more specifically about that in a couple of minutes. The other area is social movements. So there's a lot of writing, both within the environmental sphere and in with other social movements, about how you go from this sort of burst of public energy that we see here with this Earth Day photo to actually sustaining the gains of a movement. And within the environmental realm, and in other realms as well, a particular concern associated with this transition is what happens as a movement professionalizes and institutionalizes. What happens as you go from people in the streets to professionals in offices? And there's a strain of writing that is largely focused on lawyers rather than engineers or scientists, but there's a strain of writing that suggests something gets lost in this translation, that you lose some of the vitality that made the movement go, and you have a greater willingness to compromise lesser levels of energy involved. And of course, closely related to these questions are questions about how a social movement should relate to the business sector. Should it work closely with it? Should it seek compromise? Or again, will that undermine the basic values of the movement? So environmentalists talk about these questions, as I'm sure many of you know. We talk about these things all the time. But in those conversations, and when the discussion happens at an academic level, it almost always focuses on regulated businesses. Again, consultants have just slipped under the radar screen for these discussions. So the consulting industry is really big. It's really diverse. It has no clear demarcating boundaries. You know, there's not a bar exam that all consultants take. There isn't a single type of license they all have. And it's a fairly heterogeneous industry as well. So when I decided I wanted to study it, there was no way to study all of it. So instead, for this project, I zeroed in on a couple of sub-areas of the industry. One is hazardous waste site cleanup in Massachusetts. So in the 1980s, Massachusetts developed what we might think of as a fairly traditional regulatory program for dealing with the investigation and cleanup of hazardous waste sites. And at every major transition point in the process, a government regulator had to sign off on whether the cleanup plan was adequate or whether the site was clean enough. Massachusetts decided that this wasn't working. Sites weren't moving through the system nearly fast enough, so in the early 90s, it created what people in Massachusetts refer to as the Privatized program. And significantly more decision-making got delegated out to the private sector, and in order to get your site cleanup plan approved and in order to get it finalized, you just needed a stamp from somebody known as a licensed site professional. And most of these LSPs, as people in Massachusetts call them, work for private consulting companies. So there was still a significant public regulatory role. There were regulations, there were audits, there was public oversight, but much more of the work got shifted to private consultants. The other, oh, and I should also say, people in Massachusetts who I talk to, and that includes regulators, it includes environmentalists, it includes the consultants, the lawyers, without exception, love this program. They think that it has moved sites through the system much, much faster, gotten them into redevelopment, gotten them cleaned up or at least managed so that they would be kept safe, and facilitated a lot of development in urban areas that might otherwise have gone into greenfield areas. So it is widely viewed within Massachusetts as a huge success. The other program was environmental impact consulting in California. So California has a law called the California Environmental Quality Act that is a lot like NEPA, which probably many of you have learned about. It requires analysis and disclosure of the environmental impacts of proposed government projects. Unlike NEPA, it also requires avoidance or mitigation of significant adverse impacts if it's possible to do so. So it's not just a procedural statute, but it does contain all the same procedural elements that NEPA does. So this is a very public-spirited law. The idea is to foster public dialogue and to lead to better government agency decision-making. But in practice, these reports are pretty much always written by consultants working for private firms under contract with the public agencies, sometimes getting their money from the agency, usually getting their paycheck from whoever the private project proponent is. And their work isn't just writing the report, it's also handling public meetings, responding to public comments, doing community outreach. So this public deliberative process in California is very much privatized and is privatized into the hands of consultants. So for both of these fields, oh, I should also say, it wasn't random that I chose these two particular fields. I had worked in environmental consulting on waste site cleanups in Massachusetts before I went to law school. I practiced CEQA law in California after I graduated. And I wanted to choose areas in which I knew something about how the governing law worked, but also the nitty-gritty of practice, just so when I did interviews, I wouldn't make a fool of myself and ask stupid questions, or ask too many stupid questions. And this methodology obviously has limitations. These are two sub-areas of a large field, both in liberal states. And so you can't generalize from whatever findings I produced and say this is true of the entire industry or of the private sector more generally. I think the most you can take out of this is some interesting ideas about how regulator-private sector relationships could work in other realms. So anyway, the research for this project was largely based on interviews. And here you see a table of the different interviews that I did. I also, prior to doing these focused ones, did a series of more general scoping interviews with consultants and lawyers. And then I also looked at the documents produced by consultants in each of these areas. Not the ones they wrote for clients, because obviously those are being written for clients, but in both spheres, consultants have submitted rulemaking comments, and comments on guidance documents, comments on proposed legislation, other documents that basically are policy advocacy documents speaking for the perspective of the consulting field. So I paid particular attention to those, and with both was trying to get a sense of basically how this field operates, how it thinks, what values it brings to its decisions. So a few findings. One theme that emerged, both from the written documents and from the comments, is that the consultants actively seek out a role as trusted facilitators. They see themselves as in a lot of the work they do as neutral go-betweens between the clients that they represent and the regulators that they work with. And they take on this role in a couple of different capacities. So one is when regulators are developing new regulations, or are developing new guidance documents, or are just thinking about the day-to-day decisions they have to make in implementing regulatory programs. Consultants told me that they provide a lot of input there, most of it designed to basically facilitate a more effective program, or at least a more efficient one. And interestingly, regulators were very consistent in saying the input we get from consultants is really, really helpful to us. We need it, it's important, it provides us with more technical sophistication than we get from other people, and sometimes that we have with our own staff, and we also trust it. And this is kind of interesting when we think of the more standard stereotype of relationships between regulators and regulated entities, where we know that regulated entities have information that would be really useful to regulators. They know things about where regulation might not be working very effectively, how it could be made more effective or efficient, where it's counterproductive. But because the submissions of information that regulated entities provide are so often strategic or partial, selective, regulators don't really and can't really trust it. And so to have a go-between between the regulators and the regulated that is trusted, I think is actually a very valuable thing within a larger regulatory system. So it was also striking the extent to which the comments consultants made about regulators showed sympathy or support or agreement for regulatory programs. It's not on here, but I did have one consultant, actually more than one consultant in Massachusetts, who talked about the wonderful regulations, and that's a direct quote, produced by Massachusetts DEP. I mean, you never hear regulated entities talk about regulations being wonderful. But to these folks, there was a genuine appreciation for the task that regulators were up against, and a view that part of their job was to support that work. This also extended in some ways to individual client representation efforts. And this was not a universally shared sentiment. Some of the consultants were like, no, I'm just a science advocate. Others, the lawyers are legal advocates. I'm kind of a science advocate. But a lot of them drew a distinction between the way they thought lawyers operated in practice in much more of an advocacy role and the way that they thought consultants operated, where they said, no, our job is basically to work up the information, present the facts, and let the chips fall where they may. And obviously, there's an element of this that can be self-serving. We all view our own work through rose-colored lenses. And there were also some people who disagreed, at least to some degree, with this characterization of the way consultants work. I should say one of the great things about doing interview-based research is it gives you a lot of opportunities, if you're talking to the right people, to put profanity in your papers. So there was some skepticism of the consultants viewing their work through somewhat rose-colored lenses. But also, particularly when I talk to non-consultants who I would trust a little bit more to have an impartial judgment, a fair amount of agreement that, in fact, these are useful and helpful go-betweens between regulators and the regulated. Oops. So another theme that emerged from the interviews was that of consultants actually bringing a sort of quiet, sometimes you might almost say a little bit timid, but genuine strain of environmentalism into the work that they did. And I should say these two roles, I've separated them out for descriptive purposes just to make them clear. They blur a lot in practice, and it's not always, I think there are specific episodes that you could say exemplify one or the other or both, and it would be hard to draw the lines. But this was particularly striking when I was talking to the California consultants, but it came through in Massachusetts as well, that a lot of the consultants saw themselves as environmentalists. They used that specific word to describe themselves, or they talked about stewardship, or they used other sort of buzzwords that we think of as associated with the environmental field. And it was a distinctive sort of environmentalism that they had. It was not at all an anti-business environmentalism. They viewed environmental goals and business goals as compatible and thought that their role was to find that compatibility. But a genuine commitment to the underlying values of environmental laws, again, was something that the consultants emphasized when talking about themselves. And something also that the lawyers flagged when talking about consultants and saying, no, they are different from my clients, and they are different to some degree from us. Now, why is that? As this quote from a California attorney captures, there is certainly a business interest that the consultants have in the environmental movement, in environmental regulation. It keeps them employed, and they know it. No one denied that in the interviews. But when I looked at written submissions by consultants, there were a lot of them that were, in fact, focused on streamlining, on efficiency, not on undermining the basic goals of environmental law, but finding quicker ways to get there that ran directly counter to the business interests of the consultants. And so I think that while those business interests certainly make it easier for consultants to carry environmentalism into their work, it's not a simple matter of consultants professing to be environmentalists simply out of economic self-interest. There is an independent strain of values that they're bringing to the work. So a couple examples quickly of specific episodes where I saw both of these dynamics playing out, or found evidence of that both of them had played out. So one involves the formation of the Massachusetts Privatized Waste Site Regulatory Program, or the LSP program, as people call it. So this is just a clip. That's two LSPs being interviewed in a video retrospective about the creation of this program. And I talked to a whole bunch of people who had been involved in these early stages. And very consistently, they told me that the consultants had played pretty crucially important roles in helping to create and develop this program. They didn't come up with the idea of privatizing the program. That actually came from a guy from MassPerg, which I still think, and they all still think, is kind of amazing. But figuring out the nuts and bolts of it, the consultants were pretty crucially important. And in both of the ways that I talked about, both being the trusted facilitators and providing information, but then also imputing a sense of environmental values to the basic structure of the program. And this was involved in setting up the initial report that created a blueprint for the program, getting the initial legislation written, and then also with developing regulations and overseeing, creating the oversight board that would oversee the work of LSPs and their licensing, would suspend them if they did shoddy work, which has actually happened with quite a few people. The overall architecture of this program was largely built by consulting with heavy involvement from consultants. Another example involves the California Environmental Quality Act and climate change. So some of you, if you've taken environmental law classes, you may have talked about NEPA and climate change and issues about how we address climate change and environmental impact studies. Same issues have come up in California. And honestly, California has been a whole lot more aggressive in dealing with them, and I think there's been a whole lot more impact at the intersection of CEQA and climate change than there has been with NEPA. But early on, starting in the mid-2000s, there were a lot of questions about how these two laws, how CEQA was going to, or CEQA studies should address climate change, whether they should, what the intersection between these areas of law would be. And here, again, consultants were pretty heavily involved. They weren't the crusaders at the boundary. The California Attorney General's office, environmental groups like the Center for Biological Diversity, and to the extent anybody noticed, law professors like me were the ones pushing for a much more aggressive approach. And the consultants were much more focused on figuring out, okay, if this is going to happen, how do we actually do it? But a group from the environmental consulting industry in California formed a climate change committee and poured what looks, by the thickness of the reports they produced, to have been probably hundreds of volunteer hours into developing how-to guides to basically explain how to actually make analysis of climate change in an environmental study for a land use development into something workable, into something that could actually happen. Last example involves CEQA and urban development. So any Californians here? I'm just curious. So if you're from Vermont or have been living here a little while, it's important to understand that housing issues in California and real estate issues are totally different from here. We have astronomically high housing costs. We have huge mismatches in many places between housing availability and jobs. And it's not the mismatch that you have in a lot of parts of northern New England. It's the mismatches. We have more jobs than we know what to do with, and we can't find places to put the people who have those jobs. And if you're low or moderate income, and moderate income in California goes up to a pretty high amount of money, the squeeze is particularly hard. So we have what people view as a housing crisis. And CEQA gets a lot of the blame in the press, in political rhetoric, in reports put out by law firms like that one you see there at the top left. There's this trope that we hear over and over again about how the reason we have a housing crisis in California is government regulation, and more specifically, it is the California Environmental Quality Act. That's where the fault lies. And this is not sort of idle chatter in California, because there are proposals for amendments to CEQA going through the legislature almost every year, as well as rulemaking changes being done as well. And there are a lot of counter-arguments to this as well. There are people who've done some studies that say, yeah, it's government regulation, but it's single-family housing zoning and discretionary decision on each individual project that makes it so hard to build new housing. It's not the California Environmental Quality Act. But for our purposes, what interested me is the perspective consultants have brought to this debate. And again, they weren't crusaders. If you read their written submissions on this issue or on pretty much any submission, you're likely actually be very bored. They're not, there's no sort of inflammatory rhetoric. There are no bold claims there. Instead, the consulting industry took on as its role being creative tinkerers. And so that meant proposing some fairly modest reforms. It also meant doing things like saying, CEQA's getting a bad rap for housing. It's not the problem. Consultants specifically told me, no, we believe in this process. We actually want to make it work. We think CEQA done well is a really positive thing. And so when they proposed reforms, again, they were very incremental and done with the stated and expressed purpose of defusing some of the more intense debates and some of the more radical proposals and basically keeping the law intact, although perhaps a little bit better. So here you see, and again, they just churned out a lot of material, and this is consultants working on their own time rather than specific clients. So what does this all mean? So I started out by saying that I think there's relevance here to a couple areas of academic debate, one about privatization, the other about social movements. And so I'll talk briefly about each of those in turn. So with privatization, the classic debate, as I said earlier, pits at the extremes people who say privatization is great because it brings the efficiencies of the private sector to government work. And many of the strongest advocates of that view are very openly disdainful of government. So they view this as part of a sort of libertarianish agenda to shrink government, to make it less effective or less imposing, and just to get things into the private sector, which they see as better. And then at the other extreme, we have the people who say, no, the public deliberation that we get from government agencies and public law is really, really valuable. And when you shift things over to the private sector, we lose that. And that's a huge loss. So I think the consultants' examples provide a sort of partial support to the first view without the anti-governmental gloss, and a partial counterpoint to the second. And they do so in a couple of ways. So one is that obviously both of these programs churn through a tremendous amount of work and do so, I think, far more efficiently than the public sector could. And there are a lot of reasons, just for basic staffing reasons, for example, why it just doesn't make sense for a small local government in California to keep on staff somebody who knows how to produce a 350-page environmental impact report, but only does it once every 2 years. So for staffing reasons, for specialization reasons, there are obvious efficiencies in going with the private sector here. But interestingly, in both of these realms, the shift to the private sector was coupled with a very strong and continued commitment to public sector regulation. So no one in Massachusetts billed this as a sort of anti-governmental, let's kill the public sector program. Instead, here you can see a letter from the Licensed Site Professional Association that talks very specifically about the importance of a strong regulatory framework. And so what we see here is a different combination than at least you hear about in a lot of the rhetoric, where you have privatization of tasks, but continued public regulatory oversight. And it seems to be a combination that works. And there are a couple of interesting reasons why it works. One is that here in Massachusetts, at least, the privatization system in some ways actually bolstered public regulation and made it stronger because it allowed government regulators to shift their work. Before, they were having to make a lot of decisions on individual sites. They were getting very bogged down in the details. Having shifted all of that off to the private sector, they were now able to work on writing better regulations, coming up with new toxicological standards, doing the sort of truly public deliberative parts of the program, as well as providing audits and some level of oversight. So it was striking to hear the consultants talk about how they felt like the privatized program had given them a more effective and robust regulatory agency, which they saw as a valuable change. And the other piece of the story that emerges from both areas, but particularly from California, is that privatizing didn't mean a loss of public values, because the part of the private sector that this work went to was sort of defined around those public values. Through their industry associations, through their professional training, through their culture, and of course through their business incentives, the consultants who were getting this work were believers in the basic public vision of the laws that they were implementing, and often still find themselves in the position of educating the public sector on these basic values. So it turns some of the conventional narratives of privatization upside down, and I think gives a certain form of privatization, or puts it in a more positive light. Then we have movements. And the basic question with movements, again, is what happens when a movement goes from people in the streets demonstrating and all of this vitality and energy to this? When we shift to the movement being implemented by people who are doing it as a for-profit day job. And the classic narratives that you hear from a lot of academics and a lot of activists are that this is a very, very dangerous thing. So here you see a quote from Dave Foreman, founder of Earth First, that hits, I think, kind of close to home for a lot of environmental law professors, because none of us have very good tans. But the basic idea is when a movement professionalizes, the vitality goes away, its force is lost, and it's not able to accomplish the same things anymore. And he's not the only person saying this. We've heard similar things said by people in the environmental justice movement, although they didn't have quite the same emphasis about getting out in the wilderness. But that same sense of professionalization, meaning a loss of grassroots energy and vitality, is something that comes up a lot, not just in the environmental movement, but in others as well. And again, I think this story is a bit of a counterpoint to that. And I don't really have a good image to show this, so here you just see consultants out in the field. But there are a couple of reasons why. And one is just that in practice, there are too many environmental decision-making points for grassroots energy to cover. You know, grassroots energy is a wonderful, powerful, but also ephemeral thing that tends to focus on big controversies. Keystone Pipeline, great. That's a wonderful focal point for grassroots energy. Whether a particular lab at the University of Vermont is properly managing its acetic acid or its picric acid, we're not going to rally around that. You need somebody else. You need a workforce that's going to be there on a day-to-day basis to make sure that those things are being done carefully and well. And to some extent, that can be businesses themselves, but having an engaged group of professionally sophisticated people who are working on an ongoing basis with regulators and with the regulated to try to turn those bursts of energy into something that is lasting and institutionalized, I think is actually really, really important. In fact, I think if a movement is going to last, it's probably utterly essential. So even if it happens at the cost of some grassroots energy, which it might, I think the conversion of the environmental movement into this sort of work is actually an essential element for the success and the continued vitality of the field. And a partial explanation of why, even in dark times like the present, we've achieved as much progress in so many fronts as we have. So I'll stop there, and I'm happy to take your questions.
If you get that side back out. Sorry, Jeff. Any questions? It's being live streamed, so it's good for that mics.
Well, so I would say the NGOs, there's a bit of a continuum from NGOs that are sort of indistinguishable from grassroots activists. That's who they are. To others that are more professionalized, where you have something like the NRDC or the Sierra Club even has both an activist component and then a more professionalized component. And it's often, the more professionalized component feeds off the activism, is also sometimes in tension with it. The consultants, I would say, are an additional degree of professionalization beyond, well, not an additional degree of professionalization, but in terms of training and expertise, they're analogous to the professionals working with environmental organizations, but within a for-profit sector that is sort of sympathetic to business as both incentive and culture. So that results in some interesting dynamics. To some extent, the consulting firms, one person, I think I put the quote up of the person who said, everybody we hire, I think their dream job would have been the Nature Conservancy. So there's some cultural identification. There's also an awareness among the consultants that the activism is what drives the regulation that provides their work. So they are aware that there's some symbiotic relationships. And I also had consultants who specifically told me, it's important for me to build trusted relationships, not just with the regulators, but with the environmentalists. I really need them to know that when I say there are no frogs on this site, that there really are no frogs on this site. So there's those relationships as well. But I also had people, I had one person who I said, well, tell me about the cultural differences between consultants and environmental advocates. And she said, why don't you turn off your mic? I said, okay, and this was, they knew all these interviews were anonymous. So she wasn't even willing to she was willing to talk, but not on the record. So there are some tensions there as well. And the perception, I think, the consultants see themselves as the ultimate pragmatists. And that's the self-image, is that we are the most practical, idealistic, but practical people out there. And that can sometimes lead to frustration with what they see as bomb throwing.
Thank you for coming. You always select such fascinating topics to work on, and I applaud you for your care in the way in which you focus your academic work. I've run into this issue and worried about it without doing anything very productive about it in the context of NEPA analysis. Mm-hmm. And the thing that has struck me is that somewhere, maybe in the NEPA regulations that are now on the chopping block, there's some statement to the effect that the purpose of NEPA is to conduct a better analytic process and to produce better decisions, not to produce paperwork. And it has always seemed to me somewhat in tension with that principle to outsource the production of the NEPA documents. That if the NEPA analysis is supposed to improve agency decision-making, it ought to be done by agency personnel, not by outside consultants. The other, and so I'd be interested in your thought on that. The other thing that I've found interesting is the flow of the money. And the argument has been that if somebody comes along with a great big project that requires a lot of environmental analysis, then they ought to foot the bill for the environmental impact statement. And that makes sense. But then the question is, how does the money flow work? Because one way for the money to flow would be for the proponent of the project to put the money in an account managed by the agency, and the agency would hire and supervise a consultant who's responsible to the agency. But in my experience, to an alarming degree, once you accept the idea that the applicant is going to pay for the consultant, then the next step seems to be then they should be able to select who is being paid with their money, and they should write the checks. And then, you know, setting aside all the things you've said, that arrangement seems to undermine the independence of the consultants. And I just didn't know if you've looked into that problem or that issue or have any thoughts on it.
Yeah, so I'll take the two in turn. So first off, if you're big federal, on the issue of whether it would make more sense to do this internally within agencies, I think if it's an agency like the Forest Service or the Bureau of Land Management, like a federal agency that is constantly doing environmental impact analysis, the argument for outsourcing is much, much weaker because it's not like you don't have the sort of boa constrictor's diet problem with workload that you get if you're a smaller local agency. But with that said, even when I talk to people who worked for repeat player agencies like the California Energy Commission, for example, which is constantly dealing with environmental review, there wind up being these very close and symbiotic relationships where the same consulting company is working for the same agency over and over again, kind of knows what the agency wants. And you get a sense it doesn't actually matter as much whether the consultant is in-house or not in-house, because it still is the same team. There's still a sense of identification. And that can be good if the agency has a culture of doing things carefully. It can be a real problem if it's the United States Bureau of Reclamation, which would rather not do these analyses at all. To answer your second question on the cash flow, so the federal and state systems here are different. And in California, the model is almost always what you just described at the end. The project proponent pays. Typically, the agency chooses the consultant, but the project proponent may have some say in which consultant is chosen, may provide the agency with a list, or the agency may provide the private proponent with a list and say, do you object to any of these? When I talked to attorneys who represented developers about this, they said, yeah, we want as much input as we can. But it was interesting. Their biggest fear was that the work would be bad and would be legally vulnerable. And so they were basically saying, we want leverage over the consultants because we want a really thorough job because we don't want our project to get held up in litigation. So the incentive structure was a little bit different. But there are definitely these issues that arise about, you know, what happens when the consultant is paying the bill, or sorry, when the private entity is paying the bills. And some agencies actually set up firewalls. They will not let the project proponent, even though it is paying the bills, talk at all to the consulting firm other than through the formal open public comment period. Yeah, federal, I mean, sometimes it's contracted out, but my sense is that most of federal EISs are paid for by the agencies, rather than, you know, you come to the agency, I say, I want to do this, and the agency says, okay, fine, we'd like $500,000 to do an environmental impact study, and you need to supply all the data too.
I had a question. I did some work for the up in Burlington, in Vermont, and it became very clear quickly. I was managing an EPA grant, and it became very clear instantly that the consultants were the enemies, at least to the people in the community, because how clean is clean becomes a relevant question, and it's very different if you're going to live in as a stakeholder in a neighborhood versus not. And you know, the process was open and transparent, but it didn't give the stakeholders any power. Mm-hmm. And so I'm wondering what's your response to that? I mean, it really, the wheels went off quickly when the state said one thing, the Fed said one thing, the scientists said another thing, and the people living there, I did like little community assessments and things, and ghastly stories of impacts. So none of which were addressed. And you add the underlying wrinkle that the city of Burlington was also the polluter and their housing manager.
Right, so it's hard to know. So let me say generally, I've painted a positive picture here. It is not a universal picture. Like if you do a Westlaw search for environmental consultant within 10 words of prison, you'll get some hits. So, and I've been on the plaintiff side suing against some environmental studies that I thought were just ridiculously bad. So there's bad work out there by the consulting field, just as there is bad work out there by the legal field or any other field. That's a sort of general response to say it doesn't shock me to hear that story because we know that some bad work goes on. That said, the thing I wonder as you're telling the story is, are the consultants themselves to blame, or were they the fall guys for their clients? In other words, were they the ones who were sort of, in the same way that I think attorneys often, all the attorney jokes, a lot of them come down to the aggressive positions clients want us to take. And I don't know. I mean, it's hard to know in these situations whether it was shoddy work, whether it was consultants who were overly identifying with the client's interests and just steamrolling the public. Sometimes the other thing that happens is you get engineers trying to do public outreach, and that's not usually a recipe for success. So it could be any of those things.
Yes, thank you for your presentation. Very appreciate. My question also actually follow on the other question. So what's the legal remedies available for the public to hold the environmental consulting firm accountable? So my question is, if there are damages caused by the projects developed, and can the public sue the EIA consulting firm that did that EIA report? In addition to this example, your example about the waste cleanup side, if the consulting firm doesn't do a good job or better job, and could they hold accountable what liabilities they have, and whether the government that actually give the contract to that company can also be held accountable from the public side?
Right, so the typical answer is the easiest person to hold liable or entity to hold liable would be the government entity that is responsible for actually managing the site or for the cleanup. And the consultant's potential liability would be to the government entity. So if a consultant mismanages a cleanup and members of the community are hurt, most likely the way the litigation would proceed is the community members, if they've got good lawyers, will sue the government or the private entity that owns the site, which then might turn around and countersue or implead its consultant and file a second lawsuit, basically trying to transfer the liability over to the consultant. But in general, it's not easy to become what we call a third-party beneficiary to a contract. So suing the consultant directly for an injury that would be imputed to the site owner is somewhat tricky. There's some other interesting questions that have come up. So in California, there was a case where a developer proposed a project, did the basic arrangement, put up money to hire a consultant. The consultant did the environmental impact study. That went to the decision-making body, which said, you know what, no, we're not approving this. Based on the things we've learned from this study, we don't think this project should go forward. And then the developer turned around and sued the consultant, saying, you basically made our project look bad. This is your fault. We didn't get the approval. And the court threw it out. The court said, nobody owed you a favorable environmental impact study here. So the company has the consulting company has no liability.
Well, thanks for that. One last question, Dave, and then we'll wrap it up. But I have a question about whether we as teachers ought to think about the different roles of the kind of training programs that serve both of these kind of professionals, both the attorneys and then the scientists and engineers who serve as consultants. That, as lawyers, we learn about advocacy. We learn about, that's part of our whole system is the adversarial nature of it. And science, while it has elements of that, the idea that, you get to truth by lots of people pushing and pulling the same issue, the training's different. The training for scientists is really that it's the getting at the science is the core of your job. It's not to advocate for a client. And I wonder if we ought to think about the way we train these respective professionals in the environmental field to be more effective.
I think so. I mean, I think in a perfect world, a capstone project in every environmental law student's education would be some sort of either client counseling project or something where you actually are working with engineering students and science students, and vice versa. because that's practice. That's what you do. You especially if you're working on larger projects or working against larger projects, there are teams and they are interdisciplinary, and you got to learn it in practice. So it would be really great if we had more chances to learn it in law school.
Well, thanks, and thanks for your presentation today.
Thank you all.